to the most recent referral, and it's been in the news most recently, is the Libya referral. It's obviously highly contentious. It was referred unanimously by the Security Council. Ocampo, who's the lead prosecutor, requested 3 arrest warrants. Interestingly, the crime that's been charged is crimes against humanity and not war crimes. And the theme for this year is crimes against humanity, and I think that really demonstrates the utility of that charge in international criminal law, because you don't have to worry about is there armed conflict or not, have you crossed the threshold, who are the parties, is it an internal conflict, an international? You dodge all of that difficult doctrinal work, and the only threshold question is there a widespread or systematic attack against a civilian population? And of course that's easily satisfied in Libya, and so that's why that charge has been pursued. At the arrest warrant stage, the standard is, are there reasonable grounds to believe the individual committed the crime? And as we go forward, that standard of proof on the prosecutor rises until we reach the beyond a reasonable doubt standard, which is what's applicable at trial. So it's a relatively easy hurdle at this stage, and in fact it has been deemed that there are reasonable grounds. The theory of the case is that there was a state policy to quell this uprising that was happening, that we saw across the entire Arab Spring, using violence and the state security apparatus to do so. And with Gaddafi's indictment, he becomes now the 6th head of state. So he joins Jean Kambanda of Rwanda, who was prosecuted by the Rwanda Tribunal, Charles Taylor of Liberia, who was prosecuted by the Sierra Leone Tribunal, Slobodan Milosevic, prosecuted by the Yugoslavia Tribunal, President al-Bashir, who's under indictment from the ICC, and Karl Donitz. Everybody forgets about him, but when Hitler committed suicide, for 23 days he was the successor, and he was one of the Nuremberg defendants. And so we now have a fairly consistent practice of abrogating any sort of a head of state immunity when you're in front of an international tribunal, and those cases are going forward. One of the key defendants here is Gaddafi's son, who's considered one of the most influential members of his inner circle. He holds, however, no formal government position, which is quite interesting. And so the theory of liability is that he had de facto power within this, this inner circle of Gaddafi to implement this, this repressive regime. There were allegations that he had been taken into custody and the transitional government was in conversation with the ICC. These conversations were made public, creating an enormous embarrassment when in fact it turned out he was no longer in custody. It's not exactly clear what happened, but there may have been some sort of an inside job that enabled him to be released. And so that has been a major setback in terms of this indictment. Now, an interesting little factoid of concurrent jurisdiction. There is an Africa-wide court of human rights that has also asserted jurisdiction over the situation in Libya. And that court has essentially said to Libya, it's issued an injunction, we can make that analogy to the domestic system, you know, stop repressing your citizens, stop attacking, you know, innocent civilians. Of course, the Libyan government ignored that. But we have this interesting now situation where we have this concurrent jurisdiction. The ICC exercising individual criminal responsibility over identified individuals, and the African Court of Human and People's Rights exercising state responsibility, applying state responsibility to the entity that is Libya. And so these are happening now in parallel. So thinking a little bit about Darfur, this is an interesting case, and I think Fatou Bensouda was a little sensitive to this, about the symmetrical indictments. So we've indicted both sides. We've got government indictments, and we've also got rebel indictments. Interestingly, all 3 rebels who were under indictment voluntarily turned themselves into the ICC. So it's an incredible development, and really a statement about the fact that they believed that they could exonerate themselves before the court. One of the individuals managed to fight the confirmation of his indictment, so that indictment was actually dismissed against him. The prosecutor could conduct an additional investigation and recharge him, but at the moment he's back free now. This is Abu-Garda. The other 2 are now before the court. And the incident involved is this attack on African Union and international peacekeepers. All of the government individuals who have been under indictment and a leader of the Janjaweed, which is the sort of shadowy paramilitary force that is working in conjunction with the government forces, they remain at large. And al-Bashir, of course, has traveled, and he's traveled to ICC member states, Kenya and Chad, who, as I mentioned earlier, should have immediately taken custody of him and handed him over And so we're still in this situation of the court is not necessarily enjoying full cooperation from its members, and because it does not have an internal police force, that all Interpol can do is to think about Interpol as this amazing. Now, they issue an international arrest warrant, they coordinate that. That's it. They don't send people out necessarily, and so that's the situation we're in now. Next situation, Kenya. This one is interesting in that this was initiated by the prosecutor after a very long diplomatic dance with the authorities in Kenya, where the Kenyan authorities said, no, we're going to create a special tribunal, we're going to take on the obligation of prosecuting post-election violence, let us handle it, look, we've got this legislation. Well, what ultimately happened is that legislation continued to stall in the parliament. The quorum would never be there whenever the legislation came up for a vote. And so, time after time, no real forward progress was made beyond that, just the conceptual idea. And so finally, the Office of the Prosecutor said, we're going to move forward, and they did, in fact, move forward. Again, crimes against humanity have been charged. Persecution, deportation, rape, forcible transfer. There was not the threshold for an armed conflict during that post-election violence. And so again, the utility of the crimes against humanity charge. Kenya is now actively fighting this case, and I've put on there Article 17, which embodies this idea of complementarity. The ICC is meant to stay its hand in the event that a national system, either the nationality state or the territorial state or some third state, is credibly moving forward with prosecutions. And what Kenya has argued is, we've done enough. We've done a number of constitutional reforms, we've done a number of judicial reforms, we've created an ombudsman, we've created an independent prosecutor position, we are going forward with investigations. ICC should stand down. And what so far the prosecutor and the ICC have both reasoned is what we need to see is that the actual individuals whom we're targeting are the subject of domestic prosecutions. And you can't, frankly, show that yet, can you? You can show investigations, you can show intent to investigate, you can show maybe even individuals of the same level being investigated, but these 6 are not being investigated. And so until that happens, we're moving forward. Again, it's a symmetrical indictment. We have 3 and 3, both from the opposing political parties, appeasing concerns that the court is one-sided necessarily, but it remains to be seen whether the facts will bear that out about whether responsibility is equal. So, parallel with the work of the ICC often is other transitional justice mechanisms. So in Kenya, what we see is a Truth, Justice, and Reconciliation Commission. Its mandate, it's important to remember that the ICC is often situated within a much larger transitional justice agenda of a country that is emerging from a period of armed conflict or of repression against civilians. And so this mechanism has a much broader mandate. The ICC is very much limited to the post-election violence. The Truth Commission has adopted a much broader mandate that says we are going to look at the allocation of land, we're going to look at ethnic violence, we're going to look at political patronage since independence, on the theory that the post-election violence was really the tip of the iceberg, and that the roots of that were, excuse my metaphors, but the roots of that violence were planted much, much earlier, and so it would be artificial just to focus on that, flash in the pan that happened after the elections. And so they've taken this much broader mandate. They also have a lot more activities they can do. They can hear testimony from victims, from witnesses. They can think about reparations. They can make recommendations for structural reform within the country. So they have a very broad mandate. Unfortunately, the institution was plagued by conflicts of interest in the early days. It turned out that the chair of the commission was potentially a recipient witness in one of the key cases that the commission was going to be looking at, and also may have benefited from some of the land transfers that happened after independence. He refused to step down. He claimed he was innocent and that he could do his job. He refused to step down. It brought the commission to a standstill. There's one American on the commission. The only non-African on the commission is Professor Ron Sly from Seattle University. He threatened to step down if the chair did not step down, or the other commissioners did in fact step down. The chair finally did step down, so now the commission is sort of running full force ahead.